of Ghana. Nana Dr. SKB Asante, Mr. Sam Okudjeto, my Lord Justice Uni Kulendi, the Honorable Minister for Communications, Madam Elizabeth Ohini Honorable, the Indian High Commissioner to Ghana, Your Excellency, Dr. Charles Mensah, Mrs. Jean Mensah, our Minister for National Security, Minister for Information of the Republic, Justice Emil Short, Mr. Greenstreet, whose brilliant father taught me public administration in Legon, former Secretary of the Christian Council of Ghana, Honorable O.B. Amwa, my good friend. When we meet, there's a conspiracy. Honorable Atta Achia, my beloved nephew, Mr. Swanika, Ministers of State, government representatives, that will be the last. I have my comments. Government representatives, members of the diplomatic corps, statesmen and stateswomen, the clergy, civil society organizations, friends of Presec, old Presecans and modern ones, whose blue shirt I see with pride. Our beloved Chief of Staff, Mrs. Frema Ose Opare, who has honored us with a special presence here this afternoon. Distinguished invited guests, members of the media, all protocols observed, all exceptions to be pardoned, please. Constitutionalism. After the independence celebrations of the 1950s and early 1960s in Africa had turned sour and dissolved into military intervention in politics, Africa experienced the second wind of change in the last 1990s. This was a response to global demands for good governance, democratization, and constitutionalism. The continent embraced constitutions liberally, punctuated with balance of powers, human rights, freedom of the judiciary, political pluralism via political parties, and elections, etc., all guided by constitutions as the supreme law. Currently, West Africa is tragically facing threats of military coups, largely because constitutionalism has not been internalized. Some of our people do not see the constitutional option as the only pathway to peace, progress, development, and good governance. The Institute of Economic Affairs has established this center within the Institute to help address this deficit in Ghana and possibly in Africa through the Center for Constitutional Studies. The center will assist to bring constitutionalism in all that we do, translate the Constitution to the simplest terms and local languages with illustrations. It must be taught in schools, churches, mosques, and civil society generally to live by the tenets therein. From school children to local government politicians up to the national executive legislators and all, constitutionalism in Ghana and Africa should be studied, disseminated, and applied. It should be the guidepost to every activity and the yardstick to maintain or replace successive governments. A constitution is a living document and should progressively satisfy the aspirations of a people in a continuum. The Constitution of Ghana, which came into operation in 1993 after having been crafted under the auspices of the PNDC military government led by Flight Lieutenant J.J. Rawlings, is certainly not a perfect document. A number of areas of concern have sprung out of the perception of the military government and the limitation of the time whereby certain categories of people, including the Ghana Bar Association, decided not to participate in the process. The Constitutional Review Commission, subsequently set up under President Mills, was tasked to revisit the Constitution and come out with recommendations for improvement. Since then, floods of water have flowed under the bridge, and this is a call to revisit constitutional issues which touch and concern the Republic. The exercise proposed is not to rewrite the whole Constitution, but to study and recommend areas where appropriate amendments, additions, and subtractions may be made to strengthen the process towards democratization, good governance, the rule of law, equity, justice, and development in the Republic. Areas of concern include, of course not exclusive to the following. 1. The legislature vis-a-vis the executive power of the president. The president's power are legion. He has overwhelming powers of appointments and patronage, and all these will refer to the president not with regard to any particular president or whether now or gone, but the presidency. He or she is the commander-in-chief of the armed forces, fountain of mercy and fountain of honor. Particular reference must be made to legislature where Article 78(1) mandates that the president should appoint majority of ministers from parliament. The general observation is that this has weakened parliament. MPs look forward to becoming ministers. Those who are not appointed as ministers once their parties in power feel left out. In some cases, disappointed constituents vote against them, as at primaries contribute to a huge attrition rate of MPs. The legislative work of Parliament suffers because this is the second attraction to an MP's oversight, responsibility, and accountability. They become ineffective sometimes as majority of MPs bend to the executive, praying that MP's fortune will smile on them by becoming ministers. The accompanying effect is that MPs who do not become ministers are sometimes made board members of state corporations as a compensation. This also leads to conflict of interest. That is, those who have oversight responsibility over the very corporations are or may be compromised. MP ministers hardly have time for effective legislative work, thus affecting the qualitative performance of minister MPs. One tragedy of our system is that although a vote of censure against ministers is provided for, that is Article 8(5) of the Constitution, nonetheless, a vote of censure cannot remove the minister, because the discretion rests with the president whether to remove or not to remove such a minister after parliamentary censure. Notably, under the 1979 Constitution, no MP could also be a minister. We need to review this in order to strengthen the position of the MPs. Also, a vote of censure would necessarily lead to removal under the 1979 Constitution, while we should dilute the 1992, despite the stronger version of 1979, is something that we may want to wonder about. The Council of State. The president has too much power in the appointment of the Council of State members. There are three categories of members. First are the representatives of the regions. The president may influence but does not appoint. Second, 4 persons who represent institutions. For example, former Chief Justice, former CDS, former IGP, and President of the House of Chiefs. If more than 1 person is available and eligible, the president has a choice. Third, the president has a free hand in choosing 11 other persons from the region. It should be pointed out that customary, no chief in Ghana has power to appoint his elders and advisors in this way. The elders are heads of the various lineages that come to the council by right. We need to introduce institutional and representative participation and not allow the president to choose his own advisors. If you look at our customary system, I'm saying, a chief comes with the members of the chief's council already there. He doesn't appoint them. So your advisors are best advisors if they are beyond your appointment and they are separate from you. These are ingredients of our own customary system. And if we are going right by way of president needing advice as per our custom, then we must do it properly as we know by our custom. Furthermore, we need to adopt the recommendations of the Committee of Experts, which provided that the Council of State, and I quote, shall aid and counsel the President, the Council members, Parliament, and other organs of state in the performance of their functions under the Constitution or under any other law, Section 3(1). Furthermore, it was recommended that all former presidents able and willing to act as members of the Council of State should do so. President Rawlings did not want Liman to be on the Council of State and insisted that this should be removed. In other words, it is very, very important for us to read and analyze the constitutional recommendations of the time, the deliberations that informed the coming in of the Constitution itself, and things that were left out for idiosyncratic reasons or whatever, and put them right. Next, the investigative power of the Council of State, Article 92A8 says, and I quote again, the Council of State may, with the approval of the President, commission experts or consultants to advise it or assist it in dealing with any specific issue. Furthermore, the tenure could be 6 years, so that it will overlap various general elections and detach the council from any incoming president. Finally, the council should be enlarged to accommodate a good number of institutional representation. Lands Commission. Government lands allocation has been a subject of controversy in Ghana. There is a need to depoliticize the situation. First, the membership of the Lands Commission must be revisited to make the commission more independent. Second, the functions of the commission should be reviewed. Article 2571 says, all public lands shall be vested in the President on behalf of and in trust for the people of Ghana. Why would the lands not be vested in the people of Ghana? 2581 gives this function to the commission. On behalf of the government, manage public lands and any land vested in the President by this Constitution, on or by law, or any lands vested in the commission. There is a school of thought that the commission should not manage public lands on behalf of the President, but on behalf of the people of Ghana, and steps must be taken to make it more independent in the circumstances. Decentralization. Decentralization is accepted as a tool of development and participation in the decision-making process. Areas for reforms include the following. The 1/3 appointment by the President could be left to women. Political parties is a way by which local governance shall be a training ground for women for further political participation at the national level. Political parties should operate at the local level. All DCEs, MCEs should be elected to win them off executive control. This assembly elections should be 2 years away from national elections. Financial allocations should be 1/4 of the national budget. Wider functions in education, health, community, security, etc., akin to what you see, for example, in England. The judiciary. There are areas of possible reforms to strengthen the judiciary. We may look at the appointment and removal process. Judges of the Supreme Court are appointed by the President on the advice of the Judicial Council, but the membership of the Council can itself be problematic. The Council comprises 7 judges, 2 lawyers, the Judge Advocate of the Ghana Armed Forces, head of the Legal Directorate of the Police, editor of the Ghana Law Reports, 1 representative of the Judicial Service Association, 1 representative of the National House of Chiefs, and 4 persons nominated by the President. The populist approach, which lawyers have decried, is best understood when contrasted with Article 119 of the 1969 Constitution. Once more, I mention practices which were better before and how these were diluted in the 1992 Constitution for reasons best understood by looking at the political climate of the time. That 1969 provision said, those who comprise the council are Chief Justice, the most senior justice of the Supreme Court, and I want you to note the expression, the most senior justice of the Supreme Court. So you can't look at the Supreme Court and choose any judge that you like. That is where the dilution can come in. The most senior justice, that is, it is predetermined who is the most senior. When the time comes and that person is sitting there, we can know that there's no hand picking. It also provides for the most senior judge of the Court of Appeal, the most senior judge of the High Court, the Attorney General, 3 practicing lawyers, 1 person only, 1 person appointed by the President. The reference to seniority and presidential limitation must be closely examined. It definitely limits discretion in the choice of the people. Regarding the removal of judges, the case of Justice Amoasit gives us the lesson that where the executive is hell-bent on removing a judge, it is easier to do so than meets the eye. Article 146 of the Constitution provides the President receives a petition for the removal of a judge. He, the President, should refer the matter to the Chief Justice. If the CJ is of the view that there is a prima facie case, the CJ sets up a committee to investigate the complaint. 3 Supreme Court judges, 2 other persons, not lawyers from the Council of State or Parliament, nor from the Council of State, nor from Parliament, they should make a recommendation to the Chief Justice. The recommendation is forwarded to the President for an action to be taken as recommended. Meanwhile, the President can suspend the judge.